I had a client, a chiropractic client, reach out to me a couple of months ago, and she's been a great client. And fortunately, she reaches out to me when she has questions. But she said, I was approached by this platform, by a company that wants to use my practice to sell peptides to my patients. They've told me they're completely compliant, that there's nothing I have to worry about, there's nothing I have to do, that there's no risk to me, it's all upside. They will, if I send clients to them, patients to them, when they sell peptides, they will send me a portion of the revenue. What could go wrong? And so I had flashbacks several years ago to when neurostimulators were all the rage. And chiropractors were getting into neurostimulators that you put them on the back of the ear and these electrodes, and you would bill Medicare. And there were manufacturers or vendors telling chiropractors that, hey, this is completely compliant, this is completely legal, it's reimbursable by Medicare. And the truth was that it wasn't. And so over the next few years, I represented a number of chiropractors before the Department of Justice trying to help settle those types of cases. And this wave of peptides, GLP-1s, hormone replacement therapies, these peptide wellness wave felt to me like another compliance nightmare for chiropractors. And so I wanted to address it head on. And so we're going to talk about the realities that every chiropractor should understand about peptides. I'm going to spend quite a bit of time today going over the federal regulatory framework for peptides. It's somewhat convoluted because it's evolved for over a decade, and hopefully I'll bring some clarity to how peptides are regulated, some of the current events that have kind of created more confusion, and then where they are now. Once we talk about that, I will look at some of the popular peptides and we'll identify where they are in this regulatory scheme. And then finally, I'll talk about how chiropractors could, if they wanted to, implement peptides into their practice, and certainly some things to watch out for, some best practices on things you need to consider before you just go and add peptides to your practice. All right, so let's talk first about, before I should go on, let me give a disclaimer. I am an attorney, but I'm not your attorney. So what we talk about today is for educational and informational purposes only, but I think it's a good educational tool to talk about the regulatory scheme and where we are and where peptides fall. If you are approached by a group that wants to sell peptides through your practice and you have questions, please feel free to reach out to me. What I give you today is a good background, but it does not substitute or is not a substitute for legal advice about your specific situation. All right, so with that, let's talk first about the pathways to legal compounding. When we talk about compounding, what we mean is that you have a compounding pharmacy that compounds or mixes the peptides together. There are only two pathways for legal compounding of drugs generally, and peptides specifically. One is through what we call 503A, and the other is 503B. 503A is the traditional route or traditional pathway that compounded drugs find their ways to patients. They are compounded for a specific patient pursuant to a specific prescription written by a physician or a mid-level provider. If you meet the requirements of this 503A pathway, you get to skip to the front of the line when it comes to FDA drugs. For example, you don't have to go through a pre-market approval like other drugs that are marketed through other mechanisms have to go through. You don't have to prove to the FDA that you're following good manufacturing practices, and you don't have to go through the labeling process. If you meet all of those requirements, then you are in this 503. You have a route to enter through this 503 pathway. almost all of the peptides that we're going to talk about today, and most, if not all, of the peptides that are subject of this wellness and peptide wave are flowing through this 503A pathway. The 503B pathway is something different altogether. This is not for traditional compounding pharmacies. This is for outsourcing facilities. These are medications made in batch or in bulk, not pursuant to a specific prescription by a physician. But this 503B pathway, you still have to be registered with the FDA. You still have to go through the good manufacturing process certification. You still have to go through, with this adverse event reporting, and you have to be subject to certain inspections. That pathway has a separate bulks list, and we'll talk about bulks list, what that means in a moment. It has a separate bulks list from what we're going to talk about with the 503A bulks list. What you need to know is that almost all of the peptides being marketed today are flowing, at least the compounded peptides, are flowing through this 503A pathway. And so we're going to look at in detail about what this pathway involves. Let me pause and first just kind of talk generally about what peptides are. Most of you are chiropractors in this webinar, you understand what peptides are. They are usually short-chain amino acids, usually 40 or less amino chains to constitute a peptide. If it's more than 40 chains, then the FDA regulates it as a biologic. So if it's below 40, then we have this mechanism to use a 503A pathway. Peptides are used for a number of things. Semaglutide is probably one of the most popular, or terzepatide, so for weight loss, but they're also used for tissue repair, for metabolic wellness, human growth hormones. They're used for a lot of different wellness purposes. And so for purposes of our discussion, they just kind of fall under this wellness category. But the key thing to know is that they are regulated either under 503A or 503B. Most of the ones that are popular today are regulated under 503A. And let me just say, too, at the beginning, what you'll find out is that as we go through this process, almost all of the peptides that are being compounded today are not legally being compounded under the pathways that we currently have. All right, so let's talk about the three gates for this 503A pathway. So just to level set, we're talking about prescriptions that are being compounded for a specific patient pursuant to a specific physician prescription. There are three legal ways that these types of prescriptions can be compounded. The first legal way is that if the prescription or the peptide has a USP or NF monograph. USP is U.S. Pharmacopoeia, and NF is the National Formulary. And so a monograph is like an official document of USP that provides specific dosing requirements, specific standards for identity of the drug, of the strength, the quality, the purity, the packaging, the marketing, the labeling, the drug ingredients, all that kind of thing. It's a specific official document which outlines all of those types of specifics related to the drug. Most peptides do not have monographs. So most peptides do not fall or cannot enter this pathway through this specific gate. The other gate is if it's a component of an FDA-approved drug. So if the peptide is just a component of another FDA-approved drug, then that gets it through or into this 503A pathway to be legally compounded. There are some peptides that fall or can enter through this gate. Most don't. Even if the FDA-approved drug has been later discontinued, if the peptide was a portion or was a component of that approved drug, then it can be legally compounded for 503A pharmacies. Now, I will say semaglutide or terzepatide. You might think that, Well, semaglutide is a component of an FDA-approved drug, Ozempic or Wegovy, and therefore it can be compounded under this 503A gateway. Not so fast. We'll talk about semaglutide and specifically the different variants of semaglutide a little bit later as we go through talk about what the bulks list actually is. But semaglutide is a unique case that might not fit as cleanly through this gate as you might think. And then the third gate, and this is the gate that most peptide manufacturers try to enter into, is that if it is on an approved 503A bulks list. We're going to talk a lot today about the bulks list. There's a lot of different lists out there. The 503A bulks list, also called the final list, is the primary list that we're going to talk about. This is the kind of the catch-all list that all the peptides try to use to justify or claim they can be legally compounded. Pro tip, most of them do not meet this requirement. Most of them are not on the bulks list. So let me explain kind of how this bulks list works. And probably the best way to start is to back up a little bit and give you a little bit of history on how this started so you can understand where the peptides fit in and this entire regulatory scheme. So the 503 bulks list was started, in 2014, the latter part of 2013. There was a first call for a list of nominations for inclusion on this bulks list. And if it made this list, the final list, then it could be compounded by pharmacies legally. It was statutory authorization for compounding pharmacies, 503A compounding pharmacies, to compound the drug. And so the idea was that as time went on, there would be nominations for peptides that would be reviewed and follow this very specific process, which we'll talk about. And once approved, it would be on this final list, and it would bring clarity to compounding pharmacies. If it's on the list, you are authorized to compound. If it's not on the list, you are not authorized to compound. The problem was that only 6 peptides made it on this list. And after about 4 years, from the latter part of 2013 to 2017, this final rule methodology became unworkable. It became a bureaucratic nightmare. And only 6 peptides made it on the final list. After that time, it just became they got backed up, and through politics or whatever, changing of administrations, they could not get additional peptides included or other drugs included on this bulks list. So in 2017, the FDA started kind of this new process. They had actually been using this process before 2017, but think of it as like a staging area, a temporary or preliminary review of a peptide. And based on this preliminary view, the FDA would either put it on one of 3 lists. Either it would be put on a Category 1 list where you could compound, or a Category 2 list where you couldn't compound, or a Category 3 list where it hadn't been reviewed yet. So this process, or this framework, if you will, was started as a way to handle the backlog and the bureaucratic mess of the final rule, because they couldn't get additional peptides added to the rule. And in fact, since 2019, no new peptides have been added to the final list. And so here's what it looked like as of just a year or so ago. If a peptide made it to the final list, it was an authorization to compound. Compounding pharmacies could rest easily knowing that they were legally authorized. If, after the first quick review, the FDA thought, okay, this is probably going to be eligible. This will probably make it to the list someday, then we're going to categorize this as a category 1 peptide. All that means it still is not on the official authorized list. All it means is that the FDA has chosen not to enforce the rules as it applies to those category 1 peptides. We call it enforcement discretion. So all it really means is that the FDA, it's not legal yet. You're not authorized yet to compound, but the FDA is not going to enforce the rule as to those specific peptides. Category 2, on the other hand, again, this is also an interim list. Category 2 are those peptides that once they doing their quick review, they've determined that there are significant enough safety concerns that compounding of these peptides should not be allowed. Okay, so you can see that from 2017 on, we had essentially 3 lists. We had the final list, which really has only 6 peptides, so it's not really much of a list. Then we had a category 1 list, which wasn't authorization, but the FDA said, we'll just turn a blind eye to category 1. Category 2 is they're not on the official list, and we're not going to turn a blind eye to category 2. These can't be legally compounded. And then there was the category 3 that I mentioned before that just had not been reviewed yet. So it would be moved from the category 3 to either the category 1 or the category 2. And so just to be clear, those that were on the category 2 list were still off limits for compounding. The FDA said that they are significant enough safety concerns that we should not allow compounding. So what this means is that pharmacies that chose to compound anyway were facing warning letters, potential injunctions. The FDA could seize whatever product the compounding pharmacies had in stock, and they could refer the compounding pharmacies for criminal prosecution. For category 2, the FDA was saying specifically, you cannot compound this category of peptides. All right, and so that's where it was from 2017 to roughly 2023. This is what we call the steady years or the stable years. Well, in September of 2023, everything changed. In September, the FDA took most of, or 19 of the peptides that were on the category 1 list, the good list, and moved them to category 2. Now remember, category 1 was the list that it was still not authorized, but the FDA said we'll turn a blind eye. But category 2 was for those peptides that were still off limits. So the shift of 19 peptides from category 1 to category 2 was significant. Much of the marketing materials that we see today for peptides that are being sold came from this era, the 2017 to 2023, when those peptides were on a category 1 list and could be not legally compounded, but compounded without consequence because the FDA wasn't prosecuting. And so from this point on, from September of 2023, all those 19 peptides were on the category 2 list and could not be compounded. Now, what practically speaking, the way the FDA does it, if they move something off the list, for those pharmacies that already had stock on hand that was already compounded, they could continue to sell it. They just couldn't compound additional peptides, category 1 peptides that were moved to category 2. Once their stock was gone, then they could no longer compound additional what would now be category 2 peptides. There are a number of reasons that the FDA chose to reclassify these peptides. The reason doesn't really matter, but the consequence does matter, that all these peptides, and you can see them at the top of the screen now, the BPC, the body protection compound, and all these other peptides were no longer, they were never authorized, but they were no longer the consequence of compounding them was real now, because category 2s are those that can't be compounded without consequence. All right, and so that was September of 2023. Fast forward to 2024, so just a year. So from September 2023 to September 24, there was a little bit of a walk back. There was talk that these 19 peptides that were moved from category 1 to category 2 would be moved back to category 1. That's not what happened. Instead, the FDA created yet another list. They created, the list is called the Other Significant Safety Risks List. So practically speaking, those 5 peptides were removed from category 2. Now remember, unless they're on the final list or category 1, they can't be compounded. So removing them from category 2 did not make them legal to be compounded. They were still illegal to be compounded. So they were not put back on category 1. They created this entire new list. And as a consequence, these 5 peptides still were not authorized to compound. They were entitled to enforcement actions. There was no enforcement discretion as it related to them. And the pharmacies that compounded them were still exposed. If they used to be on category 1, they were moved to category 2. And at that point, the compounding pharmacies had a risk of enforcement action. And this September 2024 action did not change that. Putting it on this other list meant that these drugs, these peptides, could no longer, or still could not be compounded. Well, fast forward again to January of 2025. So just a few months after this creation of this third list, we had new guidance from the FDA. Essentially, this new guidance shut the door on these category 1 and category 2. No new drugs were going to be put on those lists. So from January 7, 2025 on, this interim list was no longer used. If they were the peptides that were already on category 1 would stay on category 1. If they were on category 2 list, they would stay on category 2 lists. But new drugs would bypass those lists altogether. There was no safe harbor. So for these new drugs that were new peptides that were proposed after January 2024, there was no safe harbor. There was no intermediate determination that would be made that would allow them to compound those peptides. Instead, they had to go through this formal review, this PCAC review, the Pharmacy Compound Advisory Council review. There was only one way to get approval, and that was to go through that formal process. And it is a formal process. It starts with a PCAC review where the FDA committee looks at and makes a determination, or at least a recommendation, and that goes to the FDA for evaluation. Once the FDA evaluates it, it goes to the U.S. Pharmacopoeia for their consultation. Ultimately, the decision, before the decision is final, gets posted in the Federal Register for notice and comment, and then maybe, just maybe, it will find its way to the final list or through final approval by the FDA. This PCAC is a process, so just being reviewed or referred to the PCAC does not mean it's authorized to be compounded. It just means that it started the process. And this process can take a long time, anywhere from 6 to 12 months, maybe even longer, depending on the politics and what's going on with the particular drug. This is going to be important momentarily, as we will start to see that this PCAC process is being implemented or used once again. So pharmacies compounding these drugs during this review process are not protected from enforcement action. They very much can be penalized if they compound these drugs. All right, so that new guidance started in January of 2025. And essentially now we have almost two parallel tracks. We have the pre-existing interim list, if they were on Category 1 or Category 2, with some exceptions that I'll talk about momentarily, they stay on those lists. They're not being, they're not all being pushed to this other process. Some are, and I'll talk about that. Otherwise, new peptides follow the new process through the PCAC review process. Okay, now let's fast forward to this year, just a couple of months ago, February of 2026. RFK Jr. in an announcement or an interview essentially says, hey, 14 peptides that were on Category 2 list are going to go to Category 1. Okay, so what he was announcing or saying was that peptides on the Category 2 list, which are off limits, we're going to put on the Category 1 list, which allows enforcement discretion. Now, let me say, HHS does control the FDA. The FDA is one of 13 divisions of HHS, and so HHS, RFK, is over the FDA Commission and the FDA Commissioner. However, announcements by the HHS Secretary do not carry the force of law. Announcements generally must go through review and comment. So this announcement that he made has no legal effect at all. The 14 peptides he said were going from Category 2 to Category 1 are listed here. They are many of the popular peptides that we see today, including the BPC 157. But again, no legally operative impact because of his announcement. And in fact, many, or some, I should say, peptide vendors are trying to hang their hats on this announcement. Now, I will say that just because the announcement itself has no effect, internally the FDA could decide we're not going to enforce these specific rules related to, or compounding rules related to these specific peptides. That they could do that. There's no published regulation that you could hang your hat on. There's no confidence you would have that this would be a long-term process, but it is an announcement, and I suppose internally they could make that decision. To date, we still have nothing formalized with regard to this specific announcement. However, in April of this year, 12 peptides were removed from the Category 2 and referred to the PCAC process. Now, remember, if they're removed from Category 2 and put on the PCAC pathway, that does not mean that they can be legally compounded. From a legal perspective, the peptides have the same status that they can't be compounded, whether they're on the Category 2 list or starting this PCAC process. So moving from Category 2 to the PCAC did nothing to change the compliance posture for these peptides. But it does start the process. Now, again, as I mentioned before, this is a long process, 6 to 12 months. The PCAC is set to review these peptides in July of this year. There'll be public comment later on. There'll be maybe a second round next year. But remember, even if the PCAC recommends approval, that's just, again, one step. And these peptides are not legally authorized to be compounded until they are on the bulks list or approved by the FDA. So we have kind of a convoluted process right now. Here, let me try to summarize kind of where we are. the only way peptides can be compounded legally is if they fall in one of these three 503A gates. In other words, 503A pharmacies can only compound these pharmacies if it's on the final bulks list, which most of them are not, because it is only 6 of them were, or it's on the Category 1 list, which many of them are not, because the FDA has now moved them from Category 2 to the PCA list, or if they are eligible as a component of an approved drug, which some are, many are not, or they have a monograph, that a USP or NF monograph, which most do not. So essentially, most peptides that are being marketed today cannot be marketed or compounded by 503A compounding pharmacies. So here's where we stand today. Here's a list of the Category 1 lawfully compounded peptides that can be compounded under the Category 1. I'm not going to try to say all of these, but that is the list. I will note that some of these peptides are approved only for topical use, not for injectable use. Several of these peptides have topical application, so lotions or whatnot, or creams. Those may be approved, but the injections are not approved for compounding. These peptides do have a lawful pathway as either because they are components of other compounded or FDA-approved drugs, or they're on the final list. Now, I mentioned earlier about semaglutide. So let me just say semaglutide particularly. GLP-1s obviously are immensely popular. And for the past several years, compounding pharmacies have been compounding semaglutide. There are a number of different legal justifications for doing so. Under 503A, you can compound drugs, a FDA-approved drug, if there is a shortage of the brand label drug. And so for quite some time, Ozempic or Wegovy, they were on the FDA shortage list, which gave the 503A pharmacies the legal authority to compound those drugs. That shortage list is now over, and they cannot compound those drugs under that authority. Another basis under 503A was you can compound, another, hurdle is that you can compound drugs as long as they are not essentially copies of the brand name drug. Well, compounding pharmacies, in an effort to not be considered essentially a copy, would add additional things to the compounding drug, to the peptide or semaglutide. B12, for example, claiming, okay, well, I've added B12, it's in different concentrations than the brand name drug, so it's not essentially a copy. Most lawsuits and most attempts to use that defense have not been successful. The manufacturers have been suing pharmacies and med spas that are using these compounded drugs on that basis, and there have been quite a few settlements in that regard. So it's not necessarily a defense or an allowance to compound those drugs just by adding B12 to the compound. Finally, I will say about semaglutide, the FDA has taken the position that many of the compound semaglutide drugs are really not components of the FDA-approved Wegovy or Ozempic. Why? Because many of these compounded semaglutides don't use the semaglutide component as it is in Wegovy or Ozempic. Instead, it uses a semaglutide salt or acetate. And the FDA has said those versions, the salts and the acetates, have different pharmacological properties to them, which make them a different component, a different peptide than what is approved in Ozempic or Wegovy. And as a result, the FDA has taken the position that those are not, those salts or acetates, since those particular salts and acetates are not on the final list and are not part of FDA-approved drug, do not enter into this pathway through that gate. And so it's unlawful to continue to compound. So semaglutide is here on the list as an approved pathway, but many compounding pharmacies aren't using the component of the semaglutide that the FDA says has been approved. They're using the salts or the acetates, which the FDA says does not qualify for this pathway. All right, so what peptides are not legally compoundable right now? Well, most aren't. So here, the top list are the ones that were recently referred to the PCAC in April of 2026, so just a couple of weeks ago. BPC 157, all of these at the top can't be compounded because they're not on category 1 or they're not part of the other lists. And therefore, if they're being compounded by a pharmacy, they're being compounded illegally. This other list, the September 24 list, where, remember, that was in September 2023, many peptides were moved from the category 1 to category 2. And then in September 24, they were moved from the category 2 to this other list. So they're still not compoundable. And so if they're on this other significant safety risk list, they can't be compounded either. And then these other drugs that were mentioned by RFK in February about going to category 1, well, they never went to category 1. They're still on category 2. And so they can't be compounded either. So as it stands, very few peptides can actually be compounded. Now, let me pause right here to make a point. Up to this point, I've just been talking about the legalities of compounding. Even if, and most of these compounds, most of these peptides cannot legally be compounded, but even if they could be legally compounded, that is not the answer. That's not the end of our analysis. If they're going to be compounded, they have to follow through. They have to meet other standards. They have to meet other standards. For example, USP standards, U.S. Pharmacopoeia standards. 797 is the sterile compounding standards, and it requires certain clean rooms, monitoring, and certain types of testing. So even if a compounding pharmacy is compounding legally, and most aren't, they still have to do so in a compliant and legal way. Some of them, especially some of the less reputable compounding pharmacies, may not be. Even if they are compounding legally, they still have to have a Texas pharmacy license, at least those in Texas, or they have to have a valid license in the state in which the pharmacies are operating. Even if you meet that standard, the drugs, the peptides, must be prescribed pursuant to a valid prescription, one that meets the recognized standards of medical and nursing care. So essentially what that means is that in Texas, a patient, before they get peptides, must have a good faith exam, an assessment that is performed by either a licensed physician in Texas or a nurse practitioner or physician assistant. A registered nurse cannot perform good faith exams. And then once the good faith exam has been performed, there must be a valid prescription, and it must be filled appropriately in accordance with state law. So I mention these things to say that there are many roadblocks and many pitfalls, if you will, to valid authorization or valid prescriptions of peptides. Well, many vendors might say, yeah, but the FDA is really not enforcing any of these rules, so we really have nothing to worry about. Well, that's not exactly true. You may remember last year, late last year, and even earlier, we had a wave of warning letters to compounding pharmacies and med spas using this compounded semaglutide. Either it was because the shortage was over, and so they could not compound because under that authority, or two, that they were compounding using semaglutide salts or acetates, and so there was no pathway for legal compounding. The FDA has been very aggressive in that regard. Even as early as April of this year, I guess last month, the Department of Justice initiated an action against a Dr. Watkins in Utah. This is significant for several reasons. Number one, it shows that the FDA is still enforcing these rules regarding compounding. So they take compounding seriously. But more importantly, you notice they went after the physician in addition to the pharmacy. So now it's the prescribing physician who is prescribing these peptides that are being illegally compounded. The physician is now in the chain of liability, and more importantly, is now subject to potential criminal liability. So it's not just the pharmacies that are involved, but it's also the physicians that are now in the chain of responsibility. Now, I'm going to pause in just a little bit and we'll answer some questions, but I just want to kind of bring this home and talk about why this matters to you as chiropractors. It's because you have been, if you're like most of my clients, you have been inundated by vendors who are offering to provide you with a turnkey solution to sell peptides through your chiropractic practice. What they offer is, hey, we'll come in, all you have to do is tell us, send your patients to us. We'll schedule a telehealth visit with a licensed provider who can write the prescription. They'll do the assessment. We'll send them the peptide from a compounding pharmacy. It is all legal. Well, let's pause. Based on what you know now, most likely the compounding is not legal because the compounded peptide does not fall within the 503A final list, and it's not on the Category 1 list. It's either on the Category 2 list, which can't be compounded, or it's in the pipeline for PCAC review and can't be compounded in the interim. So most of these peptides cannot be legally compounded. And as a result, that kind of breaks the chain of legality, because now the prescription is for a illegally compounded drug, brings liability to the physician, and these are your patients. And if something happens to your patient, and they're going to come look into you because they were connected to the peptide vendor through your practice. And so the bottom line is it creates civil and potentially criminal, but I would expect mainly civil, liability for chiropractors, anyone in the chain of responsibility for connecting the patient to the peptide. And if you are the one making the referral from your patient to the vendor, then you are directly in that chain. Let me explain another problem that I see with this type of referral relationship. Obviously, no Medicare is involved. These are all cash pay. And so as a result, we don't have to worry about federal anti-referral statutes. But we do have to worry about Texas's anti-referral statute. Texas has a statute called the Texas Patient Anti-Solicitation Act. And it applies to all patients, whether they're government patients, federal reimbursement patients, state Medicaid reimbursement, or even cash pay patients. If you get a cut of a professional fee as a result of your referral, then that is a violation of the Texas statute. And you can be liable to the Texas Attorney General's office if they file suit against you or others for this type of practice. And recently, the AG's office has been very aggressive against rooting out what they consider to be healthcare fraud. But it's also a consumer protection issue, and the AG's office has been very aggressive. All right, so let me wind down, and I want to take a few questions here. The bottom line is the FDA, most peptides being compounded today are being compounded without legal authority to compound. And as a result, that means that the vendors, everyone in the chain of responsibility has potential civil and criminal liability. If you get called to the carpet, either through a complaint, through to the chiropractic board, or a malpractice lawsuit, the fact that the vendor told you it was all legal is not going to be a defense for you. The fact that the physician who prescribed it might have a license to practice medicine in Texas is not going to be a defense for you. The fact that the pharmacy was licensed in Texas, if they're compounding an illegal compound or peptide, that's not going to be a defense for you. Every layer in the process must be done legally. And if the peptide itself cannot be legally compounded, then you are going to be in the chain of liability. So here's a practical checklist, concerns that I would have. Understand where, if you are selling peptides to your practice or thinking about it, understand where that peptide is in the process. I think I can safely say that most of the time, these peptides are not legally compoundable. They're going to be on either the Category 2 list or the category or the PCAC pipeline, so they can't be legally compounded. Also, I would say, if it is currently on the list, you need to understand that, document it, and then review that list periodically to make sure it's still on the list, because things can and do change. Even if they're on the Category 1 list where the FDA has said there's enforcement discretion, remember, that's not necessarily authority, and the FDA can change their discretion at any time. So monitor where that peptide is on the list. Talk with the pharmacy. Understand where these peptides are coming from. I don't think people require you to understand or impose rules on the pharmacy, but it sure doesn't hurt that, when asked, you could say, I actually talked to the pharmacist. They told me what their process was, and I felt confidence. I did some degree of due diligence with regard to the pharmacy. Talk to the physician, and if you don't have an opportunity to talk to the physician, get certain assertions or from the vendor that the physician is following good practices. Have good counsel review these vendor agreements and then confirm. One thing I would recommend, that if you're going to be selling peptides through your practice, these are medical services or medical drugs that require a prescription. Make sure your insurance will cover you if something happens with those peptides. Prescribing peptides are clearly not within a chiropractor's scope of practice. And so for a insurance company that is only insuring chiropractic services, the provision of peptides will likely fall outside of that coverage. What you do now in the front end can save you a lot of time and hassle on the back end. All right, everyone. Well, thank you. I hope this was helpful. Feel free to reach out to me. I represent a lot of chiropractors. If I can help with this or any other matter, feel free to reach out to me. My email address is on the screen right now, Wade Emmert, wemmert@ccsb.com. Or you can check out my website. I've got a blog at texashealthlaw.com. Thank you very much. Thank you for being a member of the TCA. It's a pleasure joining you.
The information presented in this podcast is for educational and informational purposes only and does not constitute legal advice. No attorney-client relationship is created between the hosts, guests, or any listener. The discussion of any legal topic should not be relied upon as a substitute for consultation with a qualified attorney regarding your specific situation. If you need legal advice, please consult an attorney licensed in your jurisdiction.